Secretary, will you call the roll?
Senator Abraham,
Here.
present. Representative Knox, present. Ms. Allen Bell, Ms. Heinen, present. Ms. Lagatuda, present. Mr. Lancaster, present. Judge Marabella, Mr. Myers, present. Mr. Sinkfield, present. Mr. Smith, present. 8 members present.
Okay. Thank you. Just a little housekeeping here. Please silence your cell phones. If you must take a call, please leave the committee room if you don't mind. And if you wish to give a testimony, please fill out the witness card, completely sign it, and hand it to our Sergeant of Arms. So if you want to speak, please sign it, hand it over there. Green cards are for support, red cards are in opposition, white cards are for information only. Okay, with that being said, the communication system up here is a little off. Normally, I can see who wants to ask a question from the committee. I can't right now. So if you want to ask a question, just press the button on your right. It should light up green. That means that you want to speak, if you want to speak today. And the ladies up front will acknowledge who you are and tell me, and then I'll allow you to speak. So that's kind of how we'll proceed. Sorry for normally it doesn't work like this, but we'll get through it. Also, you were handed out just an example that a committee member wrote, and that's just part of the working group. We'll address that when we get to the agenda number 2, which is the working group. Okay, I think that takes care of that, and we'll proceed with, let's see, item number 1 on the agenda is a meeting open to public testimony. So whoever wants to speak, come to first of all, you filled out the card. You'll come to the table. You'll explain, why you're for this bill or why you're not the bill, but give your opinion on this task force work agenda. Do you like where we're going? Do you dislike where we're going? And the reasons why. You might want to quote some legalese if you want to. I might have to limit the speaking depending on how many cards we have. Last time I told the committee members that we'd have a hard stop at 12 o'clock noon. A lot of times in normal committees we go on and on, but because we have people that work in the public sector, and we are going to have a hard stop at 12 o'clock if it goes that long. So with that being said, who do we have that wants to speak, Christy? They haven't filled out the cards yet? Okay, we'll wait a few minutes and have the cards, let the cards be filled out. Oh yeah, I'm sorry, but I didn't do that already. Okay, we'll back up and approval of the minutes from August 31st, 2023. So moved. Any objection? Okay, the minutes are approved. Now we'll get into item number 3, which is discussion, and we'll wait a little while until people fill out the cards, and then we'll call them up. Another housekeeping, Lauren Lampert was appointed from the Louisiana District Attorney Association, and they have designated Lauren Heinen to take his place. So Lauren, welcome to the committee, and Lauren will, I guess, be in touch with Lauren Lampert will be in touch with Lauren Heinen as this process goes forward. Okay, normally we take we'll just take all opposition first and then take. Oh, no one's speaking. Oh, well, the red cards, okay, all right.
Oh, he has one green.
Okay, Well, I'll take the first, Catalina Terrio, is that right? Did I pronounce your name right? Katrina or Catalina?
Adeline Terrio, yes, sir.
Catalina, is that Terrio or
Terrio, I'm sorry.
Terrio? That's what I thought. No, that's, hey, look, that's okay. She's present and would like to speak. So if you come and again,
Sorry,
state,
my writing wasn't that great. I was trying to hurry.
no, that's all right. And just state your name and address for the record.
Okay, my name is Cataline Terrio, 202 Acadian Lane, Franklin, Louisiana, and I'm president of the Voice Support Group, Voices of Innocent Citizens Empowered. It's a support group across the state of Louisiana, and I have brought some members, and then some members did send letters to y'all. I don't know if y'all received them.
Okay.
Okay. I just want to say that on behalf of myself and the Voice Support Group, we are very much opposed to this because I would ask each one of you, have y'all ever lost a loved one to a brutal murder? If you have, you have, sir? Okay. Okay. If you have not, then you don't know the pain and the horror that we go through every day. I lost my only child. He was brutally murdered. He was shot 3 times in the head, left on the side of the road all night by someone that was supposed to be his best friend. We didn't find out for 15 months who had killed him. He was there with us all the while, helping us to put reward signs out. He even asked to put a prayer in his casket before we closed it. And I mean, he just kept giving us information, all going to the wrong direction. And he even tried to blame 2 individuals, innocent black individuals, for doing the murder, which good thing they had an alibi because it came to light that he was the one that did it. So I believe on that night, he decided to take my son's life. My son had no choice in the matter. Marty Hebert made that choice to shoot him. He was his judge and jury that night, and he was sentenced to life in prison, and I believe that is what he should. My son has to finish his life as in death, so I believe Marty should have to finish his life in prison in Angola, and I think anything less would be a very injustice for victims and their families.
Okay, let me just try to explain. I don't think the task force is trying to do away with life without parole, okay? The purpose to me of this task force is to distinguish if someone was in layman's terms, I'm not an attorney.
Okay.
In layman's terms, if someone, me and you were riding along and I go murder someone and I pull the trigger and you were riding along with me and didn't know I was going to do that, the person who pulled the trigger, I believe, should be charged with life without parole. The question is the person that was riding along, this is simplified, but the person riding along who didn't know that was going on, should he have life without parole, he or she? So that's kind of what we're trying to delve into here. I fully understand what you're saying, and I agree with you, okay? I don't think that should be changed. But is there a tweak in the law that allows someone that might be an accessory to have life with parole? That is the purpose, I guess, in a sense, of this task force. Now, I know that it's complicated. You change one part of the law, it affects all other kinds of statutes in there. So we have to be careful on how we do that. And maybe there's not a way to do that. I don't know. Other states, which is different laws than we have come across ways to keep the person, and again, simplified, riding along from having life with parole. So anyway, I just want to kind of explain that, and I believe that all of us up here are in agreement with you. So I just want to kind of make that
Right.
statement.
And I believe in that case, it should be kind of a case-by-case basis, in all honesty. You know, I'm telling my honest opinion on my opinion
Yeah.
on it, that I think each case should be a case-by-case.
No, and that's what we're
issue.
trying to do. That's what we're trying to do here. You may or may not know, I tried to pass a bill this past session to try to distinguish, you know, that. How do you determine case by case? And we got it out of committee, but I did not run it again because I realized there was many more obstacles that I was not aware of. So we want to let the public know what we're trying to do, let the public know we're going to have the best legal minds we can to try to figure out, is there a way? But we're not trying to change what happened to you.
Okay,
So, and again, thank you for
Okay.
speaking.
okay.
Okay. Let's see, who wants to speak? Okay. Mr. Leggett,
Lagatuda.
all right, thank you.
Good morning, Ms. Terrio. My name's Margaret Lagatuda, and I work for the Public Defender here in
ma'am.
Baton Rouge. I was a prosecutor in New Orleans for many years, and I prosecuted many homicides. I also represent people, so I've been on both sides. No, we'll never know what you feel, never. But I see what it does to people, and I think that Senator Abraham is trying to get a portion of the law to leave it up to the judge's discretion on a case-by-case basis, exactly how you feel. Not you doing away with life sentence, absolutely not. But there are situations where the judge should have some discretion, and I have an example for you. I represented a lady last year who'd been the victim of domestic violence for many, many years, and one day she fought back, and he died. And that judge should have had discretion after a hearing, and him hearing evidence and making a factual finding, then he can decide, that's what the statute's about, the change, that he can decide what to give them somewhere between 25 to life.
Okay. And I just want to say my group, I would appreciate if you would hear from them.
Yes.
And they pretty much, maybe some of them might be a little different than the way I feel. So, but thank y'all for listening
No,
to me.
that's good.
And I appreciate everything, the hard work that y'all are doing. And
Well,
thank you for.
again, thank you for coming, and we always want to have people, this is what we're about here at the Capitol, to have the citizens come and voice their viewpoints. So again, thank you for your testimony, and I'll call the
Yes, sir.
next, so the other members of your group did fill out a card, I guess, right?
Yes, sir.
Okay, all right, thank you. The next person, President would like to speak, Trudy Bullard. Trudy Bullard, is that right?
Hi, I'm Trudy Billard.
Billard, okay.
From St. Martinville, 603 West Weber Street from St. Martinville, Louisiana. My son was murdered on May 16th, 2021, by a lone shooter that, in the middle of the day at 1 p.m. on Sunday morning. That morning, my son came telling me in my bed that he loved me, and not knowing to me that he went to church that day before, that same day, and told me he didn't know why he went to church, but he was glad he went to church. And I hugged him and I told him I loved him too. And then he left after dinner down the road, and I passed him up in my car, and I looked in my mirror, and that was the last time I ever saw him alive. And he walked to his apartment, and his murderer shot him, point blank. Just, they passed in the street, and he shot him in the front of his apartment door. And I went to the scene, and they wouldn't let me hug him. Wouldn't let me tell him how much I loved him. This murderer took away not only his life, took away the life of us, his mother, my only son, of me, my son, and he has 2 kids that would never see their father again. He's dead for eternity. And the person, if the case that you were talking about, if anyone else was involved in his murder, his life is gone forever in eternity. And these people that have killed other victims, their life, you can't put a date of 10 years compared to the life they took, if they're involved in the murder or if they're directly killed the murder. So it's case by case what y'all were talking about for someone else in there. But if they were judged or found guilty of being a part of that murder, my opinion is there's no date, no years set for the life they took for someone else. We're gonna live this until my last day of my life. And my son's not here. He would never be here. He's gone for eternity. And that's my opinion about it.
Yeah. Well, I am sorry for your loss. I mean that, and I haven't walked in your shoes, so I know it's very difficult. And I'm just kind of repeat. I know you came up to talk, but I don't know if you believe that there could be a case-by-case basis that somebody that was riding along with him or was part of it would not be sentenced to life without parole. I don't know how you feel about that, but again, that's kind of what we're trying to delve into.
I feel if it's a case by case, if he was directly involved with the murder, regardless if he did not pull the trigger, my opinion is he was part of that murder.
Yeah, okay. Do I have anybody, Mr. Singfield, did you?
You know, I just want to say here, we keep talking about people that are riding along and somebody shoots somebody and they have no idea. That's probably not going to be against the law. Domestic violence, and Ms. Lagatuda, if you're involved in a domestic partner is beating you or trying to kill you or inflict great bodily harm, you have a right of self-defense. That's not against the law in the
Correct.
state of Louisiana. But this bill that was put in by the senator tried to eliminate when the offender is engaged in the perpetration or attempted preparation of first-degree rape, forcible or second-degree rape, aggravated arson, aggravated burglary, aggravated kidnapping, second-degree kidnapping, aggravated escape, assault by drive-by shooting, armed robbery, first-degree robbery, second-degree robbery, simple robbery, cruelty to juveniles, second-degree, even though they have no intent to kill or in great bodily harm. But when you start in doing these violent crimes, even though you don't intend to kill the person, but you kill them, then me as a prosecutor, I think you should face that life sentence. If you're involved in a lesser degree, as a first assistant DA to 3 DAs and a first assistant attorney general to 2 attorney generals, I have the authority to charge you with a lesser offense or make you a witness or whatever. But this bill tried to eliminate and gut the very basis of the second part of second-degree murder. And that's why I showed up and opposed it. And I may be the minority on this committee inside here. Go outside these walls right now, I think I'm in a majority.
I agree with you.
If you watch the latest political goings-on, we had people running for tax collectors and things saying that they were going to try to stop murder and crime and things. So I just think the timing on this, the reality in Louisiana, the timing on trying to soften second-degree murder, the time is just not right. The reality may be, I don't know if legislation to soften second-degree murder is going to, I don't know who the new committee members are going to be, who the chairman are going to be, but I don't know if I think this is going to make it through the legislative process to soften second-degree murder when this entire state is aflamed against violent crime and murders. That's all I have.
All right, thank you. Do you have some question for Ms. Trudy?
I just want to give my condolences to you and all other speakers who are going to follow you. The question was asked that any one of us can relate, and I want to say that I can relate. I had an uncle who was murdered, and his killer still hasn't been found, and that's been over 30, if not 40 years. The killer's still out there. And to kind of echo what Mr. Singfield mentioned, the bill that was originally introduced did do those things. And the fact that they did those things, that's why we're here today. We're here today to try to correct that in the best way we can going forward. The bill that Mr. Singfield referenced, he's accurate. The purpose of us being here today, and again, I'm not a lawyer either. He's a great lawyer, so I wouldn't dare debate him on the facts of the law. But the fact, again, the bill needed fixing. The point of this task force is to fix that bill. Mr. Singfield is correct that the state, all of us sitting here, may not be in a mood to change anything about the bill. And if that's the case, then that's the case. The reality is that there are people who are charged with second-degree murder. And I just mentioned to him earlier today that Why charge them for second degree? Why not just charge them for first degree? The sentence is the same. The sentence to charge them at a second degree, in my simple mind, as a non-attorney, makes absolutely no sense. So if they killed someone, and we know that's the case, then they should be charged with first-degree murder, sentenced to prison, and never allowed to be free without probation. But that's not the case. The case of the matter is they're charged for second-degree murder. And if they're charged for second-degree murder, and some lawyer, please correct me if I'm wrong, somewhere someone thought they didn't have the intent to actually kill someone. So if they did not have that intent to actually kill someone, and they were present when the murder was done, should they or should they not be in 25, 40, 50 years allowed to have a hearing for probation?
I don't agree. Second-degree murder in the state of Louisiana is, well, first-degree murder, you can only be convicted with first-degree murder, charged with first-degree murder if it's against an elderly person or a juvenile or a drug deal. So everything else, like in my son's case, it's automatically a second degree. No matter how heinous or how heinous, how light the murder is, but he blatantly killed him, but he got second-degree murder.
And
Because he did not, it wasn't a drug deal, he did not kill a child or an elderly person. So that's what the second degree, it's, everybody, probably all was second-degree murder.
Yeah, and my uncle probably was too.
Yeah.
And so I think we're saying the same thing.
Right.
Those are the things that need to be looked at. Those are the things that need to be fixed. And that's the point of us here today, because we shouldn't be saying one murder is less than another murder.
I agree.
A killing is a killing, and therefore they all should serve the same penalty. So we're making these distinctions, and it's beyond me why we are, to be quite honest with you. And as a non-attorney sitting up here, I want you to hear me, and I said this to Mr. Singfield, I agree. Anyone involved in a murder should do the time.
Correct.
I lost a dear friend and dear relative, and I can come up with some names, and Mr. Singfield heard me come up with some names about these type of individuals. As a former Marine, I have no sympathy for them at all. And I have no sympathy for individuals who knowingly riding along with someone or assisting someone. I have no sympathy for them either, to be quite frank about it. But I do, having said all of that, I do, if someone is with someone and they're not aware and they don't know that someone is going in to murder someone, the big question is, should they have the same sentence as the person who actually did the killing? That's the question that some of us are left with. That's the question.
Second-degree murder.
I'm sorry?
It's a matter of the case where they tried, whether they charged or not. If they convicted of second-degree murder, that to me says they're found being responsible for the shooting.
And that's the conversation we're having today. And again, to me, you're preaching to the choir on this point. To me, what you're saying, I agree with. I agree with. The problem is the law, the way that it is now, it does not agree with what you're saying, what Ms. Cherio has said, and what probably some of the people following you will say. And again, I'm with you, but the big question is, does this law need fixing? And from what I hear you saying, there is some room for it to be fixed. From what I heard Ms. Cherio said, there is some room for it to be fixing. Should guilty people who go out and murder people, should they be free? No, not in my opinion, and I'm just one person on this task force. But does it need fixing? To some extent, somewhere, some way, it does. And so how that's done, that's why we're here today. And I just want to say that point for all the other speakers who will come after you, that this law needs some fixing. And we're here to try to figure out the best way to do it. But to Mr. Singfield's point, we're not trying to let people go. We're not trying to be soft. We're not trying to, I guess, be a compassionate, gentler legislature here. We're trying to fix whatever that is wrong with this law. And most of us sitting up here today, and most of you out there in that lobby, know something is wrong with the law that the way that it is. So again, my condolences to you and all the people who are coming after you. I know how you feel. I lost several loved ones, and I want to see this thing fixed myself. Thank you.
Thank you, Representative Knox. Okay. Before I turn it over to Miss Ligatuda, said that right, didn't I? Okay. I just want to address something that I'm not trying to argue with the committee members. Let's make something perfectly clear here. This is a task force to try to address this issue. This is not a task force to debate the bill that I tried to put forth in this past session. That was a template. The reason that I withdrew it because they had holes in it. So let's not make this about I was trying to do this and have people that committed heinous crimes to get off with parole. That's not what the intent was when I drew up that bill. When I realized they had parts of that bill that were not accurate, I withdrew the bill. So this is not a task force on that bill. This is a task force on the resolution that established this task force. Okay, I just want to say that. Ms. Ligatuda?
Thank you. I just want to say a couple of things, Ms. Trudy, and I can't see, I think you're behind the pole. This is not about giving people probation. This is when I ask jurors questions, they're told that they're not to consider the sentence when they determine whether or not someone's guilty of any of the levels of murder. It's up to the judge. But in this particular case, it hasn't taken out armed robbery, rape, and all that. What it's saying is the judge has the discretion that he can make a factual determination if the person should get a mandatory minimum of 25. Doesn't mean he's stuck to 25. He can give anywhere from 25 to life. He could give 99, but it's up to the judge. And I know that y'all have all, suffered a great loss, and I know that I can't relate to that or to Representative Knox, but I have for years lived with people who have suffered multiple losses. And one case in particular, when I was a prosecutor in New Orleans, it was a first-degree murder. Her husband lost his father in an armed robbery. This is the Lucky Dog case. When he was 10. He was killed in an armed robbery when his son was 10, and I prosecuted the man who shot his son during an armed robbery. So she lost all 3 generations. So I have a feeling for where you are. It's just, we're not changing the law. We're adding a discretionary part for the judge if he believes he should be able to make a factual. And I use that example of my person from last year. It was a domestic violence. But no, the DAs have much power, and they did not give her the benefit of the doubt. They prosecuted her for murder. So that's what all I'm saying, is that there are situations, and I think that's what the committee is not disagreeing with y'all's feelings about murder. It's just we want to add something and clean up, just like Senator Abraham said about this particular statute. That's all I wanted to say, and I'm sorry for all of your losses.
Thank you, Ms. Ligatuda. Okay, the next person, I guess, is related, is present, would like to speak. Mike, I guess I'm not going to say it right again. Bouillard, you said? Huh? Bouillard.
I'm the husband of Trudy. My son, Trudy, told y'all everything that y'all needed to know already about Jordan. But understanding now why we're here, my opinion about murder is an eye for an eye and a tooth for a tooth. There should never ever be a debate about that. But when someone else is with someone else that's committing a crime, case by case, if he's not involved in it and doesn't know that that's going to happen, like maybe you might have said earlier, I've known of cases that have happened in the past where someone just arbitrarily was with a friend that had a gun that went and robbed a store, and to him he was like, what are you doing? I didn't put in for this. But he shouldn't be held accountable for his actions. I get that. But knowing what he did, you know, leading up to the crime, he should be held accountable. And as a case-by-case situation, you know, a judge can use his discretion to sentence him not as much time for not committing that violent crime if he didn't know about it. But you go back to the case in 1976 when Elmo and Eddie Saunier, if we can remember the Saunier brothers that murdered a couple in St. Martinville. And in the end, they both raped the girl and they both shot the two kids in the back of the head. One was executed 7 years later, and the other one lived for another 37 years in Angola, which was totally wrong. Even back then, that was the wrong thing to do. Both of them should have been executed immediately, you know, for committing that crime because they both knew what was going on. So you couldn't excuse his behavior, the passenger, because I think, as you alluded earlier, that's what this hearing is, or study is about, is to figure out whether or not a judge can use his discretion on a case-by-case deal to determine whether the passenger or the partner in the case of second-degree murder is responsible for the same. Am I right?
That's correct, yeah.
Okay. So, like I said, I have a friend that was going to commit a pretty bad crime at a time in his life. He made a decision not to, but had he gone with his buddies to commit the crime that they committed, well, then he'd have been held just accountable just as much because he knew what was going to happen. So is that
Yeah.
kind of where we're at right now?
Yeah, that's where we are. And I guess some people believe that the law already allows to make those exceptions. I don't know if it does. And that's, again, the purpose of this study committee. When you have someone that's not the trigger man and was involved and still, you know, was murder, what do you do? And some people say, well, the law already allows that. I don't know if it's that clear. Maybe it does. I don't know. That's why we're studying it.
Depends on the evidence that
Yeah.
they collect at hand. And if he did have prior the knowledge of what was going to happen, then he is guilty. He's just as guilty.
And I think when the public, you know, and sometimes the public gets cloudy. If the public believes that we're letting murders go free, or
Yeah.
we're in the
Well,
wrong.
that's what we would
But
hear.
But once they understand that no, this is not necessarily about that. Is there certain parts of a crime that do not deserve life without parole? That's the essence of what we're talking about.
Right.
And does the law already provide someone relief in that situation? I'm not sold on that yet.
That would be based on a case-by-case
Yeah.
study with evidence, knowing if prior knowledge was there. And if it was, then it's a done deal for both of them.
Yeah.
You know, but it's,
I mean, we want to be tough on crime, okay? We do, there's no doubt
I
about
don't
it.
think y'all are tough enough. That's
Yeah.
the problem
No.
in Louisiana.
And that you
And I
very
don't
well
mean
could-
this in a hurtful way to anybody's knowledge or emotions, but murder is murder, and murder, you don't come back from that.
Yeah,
And until you walk in the shoes of someone that's actually happened to, you don't feel that. You don't really know it. And sometimes you won't make a difference by changing anything until it actually happens to you. But until hopefully Jeff Landry will become the new governor. I've written a long email, a discussion, and had a discussion with him about the death penalty, which is what I want. And I think that's what a lot of these people here are in favor of, because there's no consequences to these heinous crimes that happen for a long period of time that we get any satisfaction or feel that we have some sort of revenge of what was taken from us. You understand?
No,
I don't think a lot of people really do understand that until it happens to you, that, you know, murderers should be put to sleep.
well,
And
you know,
not 10 years or 20 years later, they should be, what y'all should come up with a bill is that when they're convicted of murder, they're put to sleep within the first year of their conviction. So that the families can have some peace of mind that someone doesn't still live with the privilege of living, even if they're incarcerated.
no,
And I know I'm getting off the
yeah,
top.
no,
the topic.
I mean, I agree with you. We want to be, I think Louisiana has increased their penalties for crime in this past session. We had a lot of, to try to be a little bit tougher on crime because we have carjackings, all sorts of things that are occurring.
And if they know nothing's gonna happen to
Yeah,
them
no,
and they're
I
gonna go
agree.
to a 5-star prison, well then,
No.
then they'll live that way.
That's right. Well, who, Mr. Knott, Representative Knott? Ms. Bynes, go ahead. Sorry about that.
I have been in your shoes, and I know how that feels. And I just want to go back and kind of narrow this down just a little bit. What we're talking about here, under the law currently, there's something called principle. Someone can be charged. Someone who may have had no knowledge.
That's right,
But the penalty is still the same.
right.
The way the law, it can happen, it does happen. Some prosecutors will never do that, some will. It does happen, and it has happened, and it can happen. This is also, what we're doing here is going forward. It won't change anything that has happened in the past. It won't allow anyone who is already serving a sentence for that sentence to be changed. This is perspective only. But what we're talking about is a factual, and you said it, a factual finding. If it is determined by fact that this person had no knowledge, had no intent, then the judge can have the option to sentence to life with parole eligibility at a certain point. Doesn't guarantee that person will ever be granted parole. It gives that,
Even if
it
he's
just
innocent.
changes that option if there's a finding of fact. And that is where the law is. The law doesn't allow that right now. And so there are people serving life without parole who didn't kill anyone.
Right.
In some cases, they may have had knowledge. In some cases, they may have had no knowledge or intent. And this is a tweak, and that's all. And I agree with you. I've been in your shoes.
Yeah.
But we're trying to make a tweak in a law that says, let's give the judge and the facts an opportunity to have that discretion.
Yeah.
And that's where we're going. That's the only thing this committee is looking at.
Right.
And
That's, it, you know.
I do feel your pain.
In his discretion, I believe the value of the crime committed when you knowingly were there, it's pretty simple. You were part of it, but if you weren't, I understand that. You know, and it can be shocking. In this day and age today, I don't know that that's ever gonna be that unshocking to think that someone was not aware of what was going on. With the way we have technology and we're connected to everyone that knows what they're doing and what we're doing. You know, years ago, that might have been the case. There was a football player in Natchitoches that was with a couple of friends that went to this little fruit stand or convenience store. And the other three guys in the car didn't know anything about him having a gun and was gonna rob the store. Well, he got killed in the process of it. But the others weren't charged with because they were unaware of what he was doing, you know? So I think that's what we're talking about.
we're just trying to allow this, the discretion to have a finding of fact.
Yeah.
And to be punished for what you did and not necessarily for what you didn't do.
Right. Okay. Well, I don't, we on the
Okay.
wrong
No,
topic of why we're
That's
here,
right. No,
but
that's good.
No, we
Well,
understand.
Thank you,
We
Mr.
understand.
if I ever come back, y'all know why I'm here.
Thank you, Mr. Bouillard. I appreciate hold on, Mr. Bouillard. You want to speak to him one more? Okay, Representative Knox.
Let him know that I do agree again with everything you said and your wife and all the speakers that's coming after you. I do agree with it, and I do want you to know, just as a matter of fact, that Louisiana is probably the most toughest on crime. We put more people in prison than any state, not just in the U.S., but in the world. So just to give you that bit of fact, so that I don't know if that's going to give you any comfort, but there's nothing about Louisiana that is soft on crime. And where we are now, and Mr. Singfield can speak to it more, we're trying to get tougher. And I don't know how much more tougher we can get if we're already putting more people in prison than anywhere else in the world. But I do want you to know that, and I do want you to know that there's nothing that we're doing here today to be soft, because we rank as high as any state could be in that regard. So I appreciate you being here, and I appreciate all your fellow colleagues and members being here as well.
Thank you, Mr. Knox.
Thank you.
Okay, the next person who's present would like to speak, and if you don't want to speak, you can wave. Carolyn Stapleton.
Yes, sir. You just said my name, Carolyn Stapleton. Mr. Singfield won't remember me, but years ago when he prosecuted Derek Todd Lee, I was the Victim Services Director for the East Baton Rouge Parish Sheriff's Office. In fact, that was my first big case. We started with all of those people. I agree with everything you said, every word. So I started off with victims from law enforcement's point of view. I was at the crime scene. I went to the courthouse with them, and then I helped them with crime victims reparations. And then fast forward many years, I also served on the Crime Victims Reparations Board for 14 years. And in 2021, I stepped off. But in 2016, I got on the back end of all of this through, there was a grant through the Crime Victims Services Bureau for DOC. And I was the person chosen for that. And I was the liaison between Crime Victim Services and Probation and Pardons Board. And during that time, I saw some things that victims weren't even being notified that there was a probation or a pardon hearing coming up. So I'm going to quickly read to y'all something maybe y'all have already read, but a lot of victims don't even realize they have rights in the state of Louisiana. And then quite often they're not enforced because we have no enforceability capability for crime victims' rights. And our rights for victims say shall. But it's pointless because nothing can be done to anybody if they don't. But the second part of the paragraph for legislative intent and rights of crime victims, RS 461841, I think is very telling from a legislative point of view. The legislature declares its intent in this chapter to ensure that all victims and witnesses of crime are treated with dignity, respect, courtesy, and sensitivity, and that the rights extended in this chapter to victims and witnesses of crimes are honored and protected by the law enforcement agencies, prosecutors, and judges in a manner no less vigorous than the protection afforded to the criminal defendants. That is something that I would say many judges, many law enforcement officers, not all prosecutors, have even read and certainly don't abide by. And I know that firsthand from being a sergeant and being a victims person and then dealing with probation and parole. I've seen it from all points of view. One of the questions that I have here is if the new law goes into effect, have y'all considered that you say an accessory? I had two cases that unusually went to court. It was gang violence, and it was two cases of gang initiation. And in both cases, the person that pulled the trigger, one person, a young boy, was killed. This was all in Baton Rouge. And another one, the old man who was just walking across a parking lot, his face was shot off. He wasn't even able to make it to court. And when asked on the witness stand, why did they do it? They said simply, well, I was told to. It was part of the gang initiation. So you have that kind of thing going on. Most cases, gang initiations, you'll never catch the person who did it. But in this two cases, it was simply, I was told to. He pulled the trigger and he was told to. So that's something that has to be considered as what happens quite often, that you never find out who did it. We have a lot of cases in Baton Rouge. You never find out who did it because it's gang initiations. Secondly, truth in sentencing. A lot of victims are told quite often it's going to be a 20-year sentence. But they don't know that that's really not truth in sentencing, because they don't know that somewhere down the road, and because I was the liaison with probation and parole, they get the opportunity after good time, after attending all their classes, to a petition for a probation or parole, whichever it may be. And here's the thing, when they get to do that, something that victims don't know either, and I saw, there's this nice little booklet that goes to probation and parole, and in it, it's bound on the side if they've had some help, and it shows each one of their pretty little certificates, okay, that they did. And then on closed circuit TV, you have their family, you have their preacher, you have their new wife that's married them, you have whoever's going to give them a job. Everything's nice and pretty and laid out. And then you'll hear a parole or probation board member say, I've heard this, in the most heinous crimes, well, I'm satisfied. He's done everything that we've asked him to do. There's nothing left to do. And that 20 years now may become 12, or that life sentence has been reduced to he's out. And then for the victim, what they're told to do is send in an email, sheet of paper. Or they have like what I have right here, and they're sitting in the audience, and they read this sheet of paper there, okay? We are not comparing apples to apples when we compare victims' rights to criminals' rights. I'm telling you right now. They're not even told they have rights. So when they go into many courtrooms, do you know, many courtrooms that I was in, that the victim and the offender's families and friends were mixed in together? That was common. It was first come, first served basis in a courtroom, and it could be the most heinous type of crime. Although we had a law that said court setting, and court setting was outside of the courtroom, and it depended on the judge. You talking about depending on the judge? It depended on the judge. Judges could assume it was outside the courtroom, that you keep the victim and offender's family separate. If you asked anybody what a court setting is, and they're just a regular Joe Blow like I was and anybody else, you're going to say the room where the judge is and the jury and everybody else. Nobody would think that at that point would be okay to mix family members of a victim with the offender's family. So do you see how awry this can go? Because I went into courtrooms, and when I did, I went in with the law. And I would hand it to the prosecutor if I thought something wasn't going to be done from a victim that should be, or if it was the judge and I wasn't going to get courtroom seating like I thought that my victims deserved. And in most cases, in Baton Rouge, judges would just, after I'd pass up that law, which they weren't aware of, they would put a sign behind the prosecutor's desk, and it would say reserved. So see, I knew that my victims were going to be taken care of, and the other side was going to be for the offender's family. That's common sense. But let me tell you what, I did run into two judges, that you know what they said? My courtroom, if you don't like where you're sitting, you may as well walk out the same door you came in. But I addressed that. I did. I addressed that with legislators. And I addressed the fact that I had a victim. You talking about victims? Him and his girlfriend were kidnapped, victims of armed robbery. The girlfriend was brutally raped. One of the guys told the juvenile shot him twice to kill him, and he ended up living. So we fast forward years later, and it's going before probation and parole. And unbeknownst to me and everybody else that I know, probation and parole, we have a law that says if you have filled out the Louisiana Victim Notice and Registration Form, you shall be notified of all hearings. And that goes all the way through to DOC. But I didn't know, because I had a victim that called and said he was told he wasn't a victim. And when I checked into it, probation and parole had added a little sentence that said, only for the victim of the crime of conviction. And I said, no, that is not our law. And I said, that's a plea bargain. And so, see, some of these second-degree murder charges, they can be plea bargains too. They can be manslaughter and stuff like that. Plea bargains happen all day long. So what I'm wondering is, if you lower this to 20 years, are you going to continue that it's going to be without suspension or probation or parole? Are you going to continue that wording, 20 years without benefit of probation or parole or suspension of sentencing, just like you have for the second-degree murder? That's what I'm wondering about that. And then I'm wondering also if it's going to be retroactive, or if it's going to start from the day of the law is passed, from that day forward, or are you going to go backwards and make this retroactive to people who's been, because like the Supreme Court, this case here, that was a juvenile lifer, so he got the opportunity to come before the parole board because it was made retroactive. It was overturned. And so victims leave out of a courtroom and they think, okay, life, I'm never going to have to deal with this again. It's over with. Or 20 years. I was told 20 years. I'll never deal with this again. So from a victim's point of view, they think they're finished with this for whatever time they're told, and they're not. They're not. It comes back and haunts them within 12 years, sometimes 7 years, and they're like, where is this coming from? And then if they weren't even told they had the right to register as a victim, they're not even in the system, because we have an opt-in system. And unless you have a very vigorous prosecutor or law enforcement service victims bureau, victims quite often are not told to fill out that form, so it doesn't follow the offender all the way to DOC. So do you see where victims fall through the crack here?
No, I understand. I have maybe 2 or 3 comments here. First of all, this is not retroactive, okay?
Okay.
Now, I do know that we have other laws that are not retroactive, yet people still file suit. I get that.
Yeah.
And that's a problem. I understand that too. But I don't want to make it retroactive, but the DAs will get lawsuits no matter what, because people are going to still sue and try to circumvent this retroactivity part of it. That's part number one. Part number two, again, I know you know, but there's no law here. We're trying to determine if there's any room to possibly bring a law, okay? If this committee cannot agree on anything, then no law will be brought, okay? So there's no law right now. Whatever you see or you read, that's just something that, I don't know what it may be, because the only thing you should be looking at is the resolution that says why we're here. The third thing is you mentioned people that had life with parole and they got it changed smaller and smaller. Again, we're talking about people that have life without parole, okay? We're trying to make a distinction on some of those people that have life without parole, making some of them have life with parole. That's at the crux of this.
And that's where the problem's going to come in. Life with parole, that 20 years is not going to be 20 years. It's going to be maybe
it could
12.
be, and it could be a judge's discretion. I mean, I don't know that, but you have that in the system already. Okay, I mean, you have life with parole, and they reduce it all kind of different ways. I mean, I have a friend of mine that should be out, and they're not giving him parole, and he didn't kill anybody. Okay, so I mean, we can go on. We have examples all over the place.
Sam.
We're trying to address some of the possible exceptions, and maybe it can't get addressed. Okay, but we have to try, and that's the purpose of this committee.
Well, you heard what I said about victims' rights. You heard what I said about some situations where they were overlooked. And then you also heard what I say. I'm 100% behind everything that Mr. Sinkfield said.
Yeah.
Thank
Okay.
you.
Thank you, Ms. Stapleton. Okay, Ms. Heinen?
I did want to just address some of the comments, because I think there's something in there for the committee to consider when it comes to victims. currently, if you have somebody who is convicted of second-degree murder, there is no parole hearings. As a young prosecutor, I have gone with victims to parole hearings for various crimes, and that process is a very, very difficult one for victims to handle. And in the instances where there is a loss of life, I appreciate all of the victims speaking about probably the worst moments in your life. I think it is worth considering what that will put families through whenever we're talking about having their loved ones gone from this world and then having to face a parole hearing where that individual that did commit that crime is actually attempting to come back into society. And so I thank you. I'm sorry, I missed your name. Ms.
Stapleton.
Carolyn Stapleton. I think she made some very good points about us keeping in mind that the victims' families should be at the forefront of our minds when we're talking about this.
Okay. Thank you, Ms. Allen. I think we have another person. Okay, they didn't check whether you wanted to present or not to speak. I'll just call your name. Is it Alma Olivier? Do you wish to speak? Yes. Okay, thank you.
Good afternoon. My name is Alma Olivier. My address is 2505 College Road in Jeanerette, Louisiana. My son Derek Olivier was a student at New Iberia Senior High, star football player. He got a scholarship to college in Arkansas Baptist College. He was about to play his first college game. He went to help one of his friends change a tire on campus, and a guy came out and started shooting the football players, and he was the only one got killed. He was on Huddle.com. He was also about to be pulled from Arkansas to play with the New Orleans Saints, and that didn't happen. The video camera from the college, they saw it. Some of it was cut out. It's been 11 years. His case still never been solved. We've had several witnesses. Even the driver, the guy who did the killing, the driver's girlfriend, she went in and gave a statement, and they all said it wasn't enough evidence. So until this day, my son's case is not solved. And we saw him in the camera. We saw the camera. We saw the film. And the prosecutors would have went on and did their job and pick him out. He would have been in jail now, but he's still walking around in Arkansas. And I don't think that's fair. My son's gone. He took my son's life and didn't even know my son. So to me, as a mother, I would love to see his life being taken from him because he don't deserve to live. I'm a mother. I brought this kid to the world. So his mom could go visit him at a jail, in prison. Only thing I can do is go to the graveyard, see my son. So yes, I would like to see justice served. I would like to see you do what you have to do, get this job done.
Okay.
But there's a lot of us, we're not getting our cases solved, and I don't think that's fair.
All right. Thank you, Ms. Olivier. Appreciate it. Okay. The next person who, again, did not put whether he wanted to speak or not, Evelyn Chillis? Chillis? Okay.
Hi, my name is Evelyn Chillis, and I'm from Four Corners, which is Jeanerette, Louisiana. In 2014, my son Ronald Chillis Jr. was murdered October the 8th, 2014, at his home. And he got shot in his house. And The guy shot him multiple times, and they had other boys with him. And they witnessed that. They didn't know what was going on. So it took us 7 years, but we got life. He got life without parole, and I just thank God for that. But it don't give me my son back, but it give me the peace that I needed. But I'm still grieving because I have to go to the graveyard, see my son.
Yes.
They can go and visit, but the other boys who are walking, I just put them in God's hand. Because some people pretend that they don't know what the people going to do, and they witness, but some of them do. But, you know, my son has 2 kids. He got to see his daughter, but his son, he never got to see. So all I can do is show my grandson pictures of his dad and good memories. But the little girl in Houston, she knows her dad. And like I said, justice was served, but it still don't give me my son back. Thank you.
Thank you, Mr. Chillis and Ms. Chillis. And again, I just feel that I should also state again for the record that we are not trying to change those sorts of circumstances that happened to your son when it was point blank murder. That's not what this committee is all about, and that's why it becomes a little difficult to say when does someone else, that we have innocent people that go to prison. We know that, okay? They are, and we want to try to protect also the innocent in a sense. And they're all going to claim they're innocent. We know that, but some of them are and some of them are not, and we're trying to see if there's a way to part that. And so anyway, thank you for coming up here and speaking. So we have 2 more cards here. Tom Costanza, President, would like to speak.
Good morning. My name is Tom Costanza, Executive Director of the Louisiana Conference of Catholic Bishops. Thank you, Senator Abraham. This certainly is a difficult conversation, but I think a good one. I personally learned a lot. I know in Catholic world and ethics, the concept of restorative justice is important. And the first restorer is the victim. And so just listening to this conversation, maybe in this dialogue, as Ms. Heinen pointed out, as we develop the legislation that, in considering the testimony of the victims, that some light could be shed on how to improve victim services. I think what it sounds like is, trying to do is use prudence, right? And that's a virtue. Trying to seek the truth, trying to administer justice. And it seems like everybody's in agreement that there may be cases where the intent was not there, but there may be cases that it was there. And it seems like this is a resolution to simply try to seek the truth and nothing more than that. And so from our perspective, we would just support a constant seeking of the truth. And this is what I think y'all trying to do. So that was just my comments. Thank you.
Well, I couldn't have said it better myself. So really, I really do appreciate you commenting and coming up here, because that really is what we're trying to do. We have no opinion one way or the other. We're trying to seek justice is really what we're trying to do. So I appreciate you coming up. Thank you. The last person at this point that would like to speak is David Trebeda. Trebeda?
Thank you, Mr. Chairman. I'm David Trappendal from St. Francisville, Louisiana. And life without parole is effectively the most severe penalty you can get in Louisiana. We haven't had an execution, I think, since 2010. So that's as bad as you can get when you've committed a crime. And Louisiana, I believe, has some 6,000 people who are effectively serving life without parole. And that's more than, I think, Texas, Arkansas, Alabama, and Mississippi combined. And so if giving people life without parole was the solution to our criminal problem, then we should have a much lower crime rate than the other states, but we don't. And so there should be, in my opinion, some discretion so that where the severest penalty that you can possibly give is warranted, you give that person that. But in cases where there are mitigating circumstances or where this person did not deliberately, intentionally, first-degree murder, kill somebody, it makes perfectly good sense to me that a judge should have the discretion to be able to say, this person should not be automatically given the severest possible sentence that can be handed down by the state of Louisiana. I mean, we elect judges to be judicial, to have common sense, to be able to look at the whole thing. And I think we need to give judges the discretion so that they can do that. That's all I have to say.
Thank you. I appreciate it. I think Mr. Singfield, you want to have a comment?
On that, when you get into judicial discretion and you look historically, I used to work for a DA right here in Baton Rouge. I was his first assistant for a time, and he had a sign on in his office that said, "Soft judges make hard criminals." And the problem is that historically in Louisiana, if you follow it historically, the creation of these mandatory minimums and the creation of life without suspension, probation, parole comes from what a lot of people like these victims' family members out here believed was abuses of that discretion or use of that discretion in the favor of hardened criminals instead of the victims or their family members. That's what creates that. So we have wide divergency in judges across the state. And what was being seen is in exactly the same crime, or as close as you could see, identical, some of that discretion was used in favor of the convicted criminal. Some was used against. There wasn't consistency. And so when that happened, victims groups in Louisiana stood up and you started seeing a lot of these mandatory minimums put on certain types of crimes. Recently, fentanyl was all in the legislature, and I think they put, I'm not certain of that, but I think they put some mandatory minimums. Even this original bill, fentanyl was exempted from the drug exclusions that was attempted. So there's more to that than just saying, and I've worked in some judges that were inspirational to me in my 50 years of prosecuting in Louisiana. I worked in some that was less than inspirational. There's a sign in my office that says catch and release fish, not felons. And there's a history that created this. And I can assure the gentleman that just spoke, in reality, there's no such thing as life without suspension, probation, or parole in the state of Louisiana. And I'm going to quote Lauren Lambert. I think I got this right. Maybe you can correct me. But I think the last meeting, he said that it had been like 140-something commutations of life sentences in the last 90 or 96 months. I don't know what he said. And I can't verify those figures. I'm just trying to quote Lauren Lambert, who's the head of LDAA. I can quote some myself because one of the most violent murders that I prosecuted in my career, the person that did it is walking around Baton Rouge right now. Last time that I saw him, he was receiving life without suspension, probation, or parole. So, I mean, the reality is that you have commutation, and I'm not opposed to commutation. Apparently, it's working for some of these people, or if Mr. Lambert was correct, a great number of them in the past a few years. So I'm not opposed to that, but there's no such thing as an absolute in the state of Louisiana, in most states. And a lot of what they're talking about is second-degree murder under the second part of this. In other states, is actually manslaughter or lesser degrees of their murder statutes. And a lot of this business, we're not talking about apples and apples. There's differences when you look at these things. So, I'm just saying, leave our statutes alone, and the people that don't know the crime was going to be committed, that's not against the law. You got to be engaged in perpetration or attempted perpetration of these crimes to even qualify. And then certainly we have elected district attorneys that have discretion to reduce these cases, and there is some discretion. For example, in our manslaughter statute, I know there's some exceptions for guns, this, that, and the other. I hadn't read it, but there's great discretion in some of our criminal statutes for the judges to use. I'm just urging that we, like we say, we consider the victims in here, and not all of a sudden, in these days and times, the timing is off on this legislation. This bill that the senator, I'm not certain, did it go through the Senate committee and the Senate before you withdrew it?
It went through the committee. Yes, it passed through the committee.
That's what I'm saying. It was withdrawn, I thought, in the House.
No, I withdrew it myself.
You could.
It was
Well,
my-
I think the senator has honorable intentions. I don't have any problem with the senator's intentions, but I'm just saying, like a lot of these people in here, if like you, like me, where I've been out these scenes where the blood's still flowing out of somebody's body, it'll change your mind real quick when it's you. So I don't think it's time in this state to soften the penalties for second-degree murder, although I do believe there is avenues for people, like it's been described here. There are avenues through commutation and pardon boards, whatever, to have a chance to have some of their sentences reduced. And in some cases, I'm not opposed to that. Thank you.
Thank you, Ms. Sinkfeld. Who else? Ms. Heinen?
Yes, I do believe your number that you gave, it might be a little bit closer to 200. But I think the point was made that there's discretion everywhere already. And there have been issues with that have, like you said, caused some mandatory minimums and that sort of thing within sentencing. But one of the most obvious things that I've noticed in listening to everybody speak is we're talking about knowledge and intent. If there's no knowledge and intent, it's not second-degree murder. We have a statute that covers that, be manslaughter. And so I think for this committee is going to have to consider those laws in total to see that there is some stopgap measures that can capture the issues that have been discussed. We've also heard accessories and principals. I think there needs to be some delineation between that because it feels a little bit blurred. If we're talking about accessories, if we're talking about principles, and we're talking about intent, if an element of that crime is intent, and then we give a judge discretion to then say, after prosecutors have proven intent, I don't think that the intent was here, even once it has been proven, and a jury has doled out a sentence. I think that is problematic. You're directly conflicting in that discretion, and I think it leaves a really big hole wide open that is very concerning as a prosecutor and as a citizen. I think that gives a really big opening for a judge to circumvent an entire case that was presented. And so I think those are things that really need to be looked at with a really, really good eye in terms of how that's actually going to be addressed.
And thank you, Ms. Heinen. And I agree with everything you said. And when I first put this bill in committee, because I'm not an attorney, I just was looking at, I think there are some exceptions that are not treated right. But the more I got into it, the more I realized there was all other aspects of law that you could use. And so then I quickly realized I was way over my head, okay, in trying to, I know my intent was right, but there's so many different legal statutes that address certain things that I knew that I couldn't overcome it. And I didn't feel right about moving this legislation forward. So that's, again, I'm repeating myself, this is why we have this committee here, to see if there is anything that's slipping through the cracks that we can correct. And if there's not, then that's fine. At least we've done what we're supposed to do, which is try to find a way to keep good people from going to prison. When I say good people, I mean people that did not have the intent, okay? That did not have the intent from actually going to prison without parole. So anyway, with that being said, I have a couple of people that want to, Ms. Ligatuda, I think you want to speak.
I do, just briefly. Thank you, Mr. Chairman. I know that Ms., I don't want to say your name wrong either, Ms. Hyman, is it Hyman?
Heinen.
I also was a young prosecutor, but I think I didn't want to get into legalese and the law in detail, but for the group to know that 2 years ago, Louisiana, along with Oregon, was the only two states that you could be convicted of murder without a unanimous jury. And the United States Supreme Court finally ruled on that in April of 21. And that they did not, it did not go retroactive, but anybody who was still on appeal or any legal post-conviction issues was eligible for their case to be retried. And I think that's some of the numbers they're talking about, that some district attorneys, and I know all of them, have gone back and looked at cases. And do we have the witnesses? Do we have what we had 5 years ago or however long back it was? Maybe not. And some people were, and I know this because I'm a boots on the ground person in court every day, that some people's cases were renegotiated and they may have been convicted of murder, but now they didn't have the evidence to go forward. So that could be some of those numbers. We're not talking about a free-for-all to let people out. I'm a citizen. I want the people that commit the crimes to do the crimes. I'm also a public defender, and I know that not everybody arrested is guilty of a crime. So I'm going to do the best job I can to represent them and that they are fairly convicted. So now every felony, including homicides, has to be unanimous. And that's probably the best way, and unfortunately Louisiana was not that way for many years. You could have two people out there and that would give you still a legal verdict. So it's tougher for DAs, and it should be tougher for DAs. They have to prove their case with evidence. And evidence is witnesses, evidence is physical things, evidence can be a video. But we just want to give a judge, and I know Mr. Sinkville, and I have too, been in front of judges that were inspirational and some that were not. And I've been in many parishes, so I know this. So, but there are more cases that are just not cut and dry, black and white, that we just need to give them some discretion on those cases. Not automatic. They got to have a factual finding. There's got to be a hearing. Not going to mean they're going to eliminate you from testifying. That doesn't say that. It's just to give a tweak to this. We still should have life without parole, probation, or suspension of sentence, and that is called in the law without benefit of probation, parole, or suspension of sentence. Some people need to be in jail for the rest of their lives. I know this. I represented them and I've prosecuted them. But there are some, not all, nowhere near all, some that the judge needs a little discretion, and that's what our focus is. Thank you.
Thank you. Representative Knox?
Thank you, Mr. Chairman. I just want to echo the previous speaker comments and add real quickly that, again, this whole point is to fix what needs to be fixing. If this task force determines nothing needs fixing, then so be it. But I think there is some consensus that we need to look closely at those items that do need to be fixing. What struck me at our last meeting, and in all fairness and in transparency, I get a lot of support from law enforcement, and I'm proud of that. But what struck me, and it was mentioned, if I'm not correct, Mr. Singfield, that you mentioned that this statute is also used as a tool to get people to admit to certain crimes. And please correct me if I'm wrong. That concerns me, because it speaks to a broader issue that we use certain statutes as a weapon to get certain people to commit the crimes that they didn't actually commit. So there is no doubt that there are some people, and not all, and I'm not defending anyone. I'm the least person to be defending anyone. Mr. Singfield knows this. But when you get in a position where you're using the law and you're weaponizing statutes to get people to admit to something that they ordinarily wouldn't admit to, that's problematic. That's problematic. So if you can imagine for a moment someone that you know, and they could be joyriding with a friend. They can be going to a party with that kid that you know he or she shouldn't be around. They can be at a college party, at a frat party, and they're riding along with some knucklehead. And they're caught in a situation. They're at central lockup. You got a hard-nosed prosecutor. You're confused. You don't have anyone there who could speak the legalese to explain your rights to you. And when someone is weaponizing a certain kind of statute to get you to admit to something, that's problematic. And again, I'm not defending anyone. I'm proud of the reputation that I have when it comes to law enforcement. I'm proud of my stance on victim rights. I'm proud of my stance on fairness. But I said all that to say, let's be fair here. Let's just be fair to consider what are we really talking about. I mentioned to Mr. Singfield that if someone is guilty in a commission of a crime, particularly a murder, no one has any sympathy for them. Let them go to jail and do the time. You heard the father mention, even he understands that. If you're riding along with someone, some knucklehead, some stupid, some monster, some crazed person, go and do something so heinous, and you're riding along, you're drunk, you partying, your mind is somewhere else, and you're charged with a crime that's equal to the crime that they did, is that fair? It's a basic question. It's something that we need to look at. And that's all we're doing here today, is looking at if it's fair or not. It doesn't make any sense to you, the average person, like you. I'm an average person like you. I get up every day, I work every day, I go to my job, I do my business like you. I'm not an attorney, I don't understand the legalese, but as a basic person, even I know something doesn't seem right about a person who had no knowledge of a murder taking place, who didn't know that that's something that they were involved in, who's just along to get along, who's coming from a frat party, who's coming from a football game. Does that person deserve the same penalty as the person who actually pulled the trigger or committed the crime? That's what we're trying to figure out, and that's what we're trying to determine. We're not trying to get soft. We're not trying to weaken the law. We're trying to fix it for basic fairness. And I'll be the last person to defend someone who knowingly rode along with someone who pulled the trigger, knew the person was going in to pull the trigger, I don't have much sympathy for them. And I think most of you don't have much sympathy for that person either, who knowingly knew they riding along to go with someone to commit a crime. I don't have no sympathy for that person. I don't mind that person getting the same amount of time because they had the right to make a different decision. But if the person who didn't know and they're caught in that situation, we got to get some fairness for that. And we have to look at how we're going to fix that. And that's all I want to say today. If I can leave you with anything, in my simplistic way of communicating, just think about the basic fairness and what we're trying to look at today and how we're trying to go forward. Thank you.
Thank you, Representative Knox. Let's see, I think Mr. Myers.
I want to address some things that were brought up earlier, and maybe just to put some minds at ease. We have considered this issue of the person, the gang issue that was represented earlier. We kind of called it the kingpin issue, that someone ordered someone. That would not be considered for this. That would be a factual finding that would not be considered for parole eligibility. That person would be the responsible person, even if they didn't pull the trigger. That is something that we have already considered and looked at. It has been addressed, and that person is just as culpable as the person who would have pulled the trigger. That is a finding of fact. A person, the narrow scope that we're considering here does, I think, have a truth in sentencing component, because if it says you have life with parole after 25 years, it's very well known that at 25 years, that person would have parole eligibility. Not released, but parole eligibility. And the reason for that finding would be that that person had no knowledge, no intent, and that would be a factual finding. This is about truth-seeking. I think that was put very well. This is about tweaking and refining and being about truth-seeking. I would also say that while they may be statutes that address certain issues, the issue of judicial abuse was brought up. There's also many cases of prosecutorial abuse. It happens on both ends, and you can't just put the finger on judges. I don't think judges would appreciate that either. But trying to make the system work better, trying to make the system more equitable, is what this committee is trying to do. And I think it boils down simply to that. Trying to tweak something that makes someone be accountable for their actions and punished for their actions in the actions that they took and nothing else.
Thank you, Mr. Myers. Mr. Sinkfield.
I just want to address some of what Mr. Knox said. Prosecutors don't try to grab innocent people and weaponize them and use them as witnesses. Most of the time, what you have is a number of very guilty people, and their attorneys show up at my office and say, hey, can my client get a deal if he agrees to testify? And here's what he has to offer if you give him that deal. Oftentimes, prosecutors, when they get cases, this is what they're faced with. Easy decision is the police have arrested somebody and it's obvious, or maybe not obvious, but it's very likely that they didn't do it. That gets rejected. I wish Lauren was here and he could give the percentages of cases that charges are rejected by DAs because the DAs either think the people are innocent or they don't think there's evidence there to prove it. Second category is very difficult, where it's obviously that the person is guilty, one, and two, that it's obvious that you can't meet proof beyond a reasonable doubt to a moral certainty in front of 12 people. And a prosecutor has to make a decision to turn a guilty person loose. When the evidence there that they're guilty and you have the evidence, that's the easy part. But those I've never heard, or I've never weaponized or tried to use an innocent person as a witness. If you did and you accused him of crime, it's going to come out. And what you have to do when you use a person that you made a deal, you have to make full disclosure to the defense attorney, the judge, and the jury. And I always believed in going overboard to that, even if it was, I bought him a Dr. Pepper while he was interviewing in my office. So I don't believe that, actually happens. Another thing that I can tell you is there's a misconception that defendants that are appointed public defenders get lesser representation. Now, they may in some cases, and sometimes I don't agree with the way that the money is spent that's devoted to public defenders, but some of the best trial attorneys I've been up against in my life were career public defenders that have been in those courts. They've defended hundreds, maybe thousands of cases. The judge likes them. They know when to seek to use their clients as witnesses or get deals for them. It hadn't been my experience. Right in the middle of all that are some of the finest trial attorneys in the state of Louisiana in those public defender's office. In particular, I don't know now, but years ago, they had some excellent ones in East Baton Rouge Parish. So that's another thing that I don't want people to fall for. Years ago, I was invited to speak to the Criminal Defense Attorneys Association of either East Baton Rouge or the area. And my office warned me that probably I shouldn't do this. But I went and I spoke and I told them, look, I know a lot of y'all don't like me, but here's what I can tell you. I've saved more people from being prosecuted for second-degree murder than any defense attorney in this room, because I put myself in the positions in office to have the discretion to try to prevent innocent people from being prosecuted. And I used that discretion, which sometimes wasn't popular with people. So I don't think I'm going to sit here and agree that prosecutors weaponize innocent people to convert them as witnesses. Thank you.
Thank you, Ms. Sinkfeld. As you can hear from this committee, it's a diverse group, and it was planned that way. And there's a lot of different opinions. So we're going to move on to the last item for discussion, which is the creation of a work group within the task force to discuss future legislation. And so on this work group, I know this involves to me, you have to be an attorney in a sense to be on this group. I'm not an attorney, so I'm not on the group. But I would like to appoint 5 people and from 5 different aspects of our society, you might say. I'd like to appoint retired Judge Tony Marbella to be on the work group. I'd like to appoint Lauren Heinen from the District Attorneys Association to be on the work group. I'd like Miss Margaret Ligatuda from the Public Defender's Office to be on the work group. I wanted someone from a professor at law, and Robert Lancaster, and I liked him to be on the group. And then I still needed a hard-nosed guy on the group that could still represent the Attorney General's office. And Mr. Sinkfeld said, you probably don't want me on this group because you know where I stand. I said, well, no, that's why we want you on the group. So anyway, so those 5 will be part of a work group, and you can use your own staff, I guess, in the sense y'all can have Zoom meetings, but just try to formulate a plan that could be acceptable to address what we're talking about. If you cannot and it becomes too much, then we understand that too. But I can't think of any, us as non-attorneys, I don't think we would be as useful on that group. So anyway, any other questions along those lines? I'll move to item number 4, any other business for the group. Again, I appreciate everyone being here, the people that came to testify, the people that are listening, people listening at home. We're just trying to represent the citizens of Louisiana to the best of our ability. And if we can tweak something that makes it better, we will. And if we can't, we won't. So thank y'all. I'd entertain a motion to adjourn. Motion to adjourn, so moved. No objections. We're adjourned. Thank y'all.